This is a University of Otago podcast.
Tēnā rā tātou. Ka tū tēnei ki te mihaki atu ki a koutou me ki a tātou, ko tata mai I tēnei ahi pōno reira. Tēnā rā koutou. Tēnā rā koutou. He mihi tēnei mai I te mana whenua o tēnei rohi. Ngā hapū, ngā whare, o te tai, o araita uru e mihi atu ki a koutou I tēnei pōno reira, tēnā rā koutou, tēnā rā koutou. Nau mai, haere mai koutou. Haere mai ki tēnei whenua, haere mai ki tēnei whare, haere mai ki tēnei kaupapa o te pōnei no reira, tēnā rā koutou. Tuatahi me mihi atu ki te roka rawa nōna ka mea katoa I haka nō reira. Hei honore, hei karoria ki te atua, he mokoroko ki te whenua. E whakaro pai ki ka takata katoa. Tuarua, tika hoki tēnei wā ki te mihi atu ki a rātou kua whitira ki tia. O te rā, o te wiki e te marama te tau. Rātou katoa kua whitura ki tia, haere koutou. Haere ki te wākaika, haere ki te kaika tūturu, o ki rā. Ka huri ka mihi ki a tātou nei, ka kaanahi ora tēnā rā tātou anō. He mihi atu tēnei ki a koutou, ko tai mai, mai tika Maori, mai te taitokarau, mai ngā wahi katoa, o tika Maori koutou, o mātou nei rangatira mai Ngāti Whātua. Tēnā rā koe e te rangatira. E mihi atu hoki tēnei ki a kōrua, mai I Ngāti Ranginui, me Ngāti Raukawa, ki a kōrua me ki ngā kaipakahari, o tō kōrua nei iwi, nau mai hara mai, ki tēnei, me ki tēnei whānau, ki tēnei kaupapa. Ki te whakanui me ki tēnei o tā tēnei taonga, no reira, tēnā rā kōrua, tēnā rā koutou. E mihi anō tēnei atu ka koutou mai te haikainga nei, koutou katoa, tō mātou nei whanauka, koutou hoki ngā kaimahi o tēnei whare wānanga, koutou hoki te whānau, ngā whānau kua tata mai ki rungi I tēnei kaupapa nunui mō tātou no reira, nau mai hara mai. Kaore kumurua tēnei tū, ingari te mea tika māku ki te tū, ki te mihi atu ki a koutou me ki a tātou. Ka huri anai nei ki te reo tūrua, ki te whakamārama oku nei kōrero. Nō reira, kia ora, greetings, welcome. It's a privilege and an honour to be standing here welcoming everybody this evening to this amazing event. And mihiing to so many of you who have come from both far away and also a bit more closer to home. We are particularly honoured to have very distinguished visitors from Jacinta, Ngāti Ranginui and Ngāti Raukawa, and also, of course, our matua from Ngāti Whātua. I guess this is going to go down as a pretty good year. It started off on the 1st of January, stepping into the role as co-director of Ngā Pai o Te Māramatanga, which, as you all know, is huge for everybody. 1st of February was first official day in the role of professor, and then only last week or the week before, being awarded the Prime Minister's Supreme Teaching Award for the whole country. So really, there's not much more I can say. Bit of an overachiever. No, I think what needs to be acknowledged, though, is that all hasn't come about by accident. It's come about by amazingly hard work over a long, long period of time. And as always in these circumstances, we acknowledge and honour the family and friends who have supported the journey. We look forward to the journey that's still to come. And it's particularly pleasing that none of that has affected Jacinta. She's still humble and lovely and supportive and helpful, as always. So I think there's a lesson there too. But for all of us, I mean. So once again, thank you all for coming. Kauri, kumurua tēnei tuingiri te mea tika māku ki te mihi hatu ki a koutou, he mihi whakatau, nō reira whakatau mai, koutou katoa, tēnā koutou, a tēnā koutou.
Inga mana, inga reo, inga tā wira pumanawa, ro rakatera mā, tēnā koutou, tēnā tātou katoa. Good evening. My name is Harlene Hain, and I have the great pleasure of being the Vice Chancellor here at the University of Otago. And on behalf of the university, it is my great pleasure to welcome you to this inaugural lecture for Professor Jacinta Ruru. Now, as you often hear me say, these IPLs are an incredible opportunity for each and every one of us to take time out of our busy schedules and simply bask in the glory and the scholarship of one of our own. I'd like to extend a particularly warm welcome to members of the community who are here with us this evening, not only the University of Otago community, but the wider Dunedin community. And I'd particularly like to extend a warm welcome to members of Jacinta's whānau, who quite rightly will be sitting here this evening with an immense sense of pride. In particular, I'd like to acknowledge her mom and dad, who are here. So Norm and Andrea, very welcome, warm welcome to you, and also her mother-in-law, Edith Geddes, who is here as well, and to her partner, Professor Andrew Geddes, who I haven't seen, but I hear is wearing a suit. Yes? Well done, Andrew. Her brother and his wife, Jared, and Melanie Ruru are also here with us this evening. And as Tuari already acknowledged, there are representatives from her grandparents' iwi who are here with us this evening, as well as representatives from Ngāti Whātua. And I would like to extend a warm welcome to all of you. And I would also like to extend a warm welcome to the tangata whenua who are here, including Edward Ellison, who we really appreciate you being here this evening. Edward, it's fantastic to have you here with us. But tonight is not only a special occasion for Jacinta's family and friends and her iwi, it's actually a very special event for all of us. Tonight, as a university community, we acknowledge the promotion of the first Maori professor of law in New Zealand. Now, as Tuari already mentioned, Jacinta's promotion has actually come on the back of years and years of hard work and scholarship. In order to be promoted to the rank of professor here at the University of Otago, an individual must exhibit excellence in teaching, in research, and in service to the university and the wider community. And this year alone, Jacinta's hat trick of promotion to professor, coupled with scoring the Center for Research Excellence and the Prime Minister's Teaching Award, is certainly a very clear indication that she has met the bar on all three of these occasions. But one thing I want to mention that may be less obvious to people in the audience is Jacinta's service to the university over the years. I first met Jacinta actually when I was the DVC Research and Enterprise, and at that time, every committee, every working party, every review panel requested that Jacinta was a member of their particular group. In fact, her services were so sought after within the university that I eventually had to put a temporary fence around Jacinta so that she could protect her teaching and research. She is obviously a very valued member of not only the Faculty of Law, but also the wider university community. Now, in the course of making our decisions about whether or not we promote someone to the rank of professor, we seek the views of experts in their particular field of research. And when we sought input about Jacinta in the course of evaluating her application for promotion to professor, we heard things like, Professor Ruru is a brilliant and groundbreaking scholar. And Jacinta Ruru is a remarkable young legal academic, one of New Zealand's very best and a torchbearer for her generation. And last but not least, we were admonished that this promotion is very long overdue. So Jacinta, with no further ado, I would like to congratulate you on behalf of the University of Otago on your very well-earned promotion to professor. And I will now call on the Dean of the Law School, Professor Mark Hennigan, who will tell us just a little bit more about Jacinta's academic journey. Nō reira, tēnā koutou, tēnā tātou katoa.
Kia ora koutou katoa, haere mai, haere mai, haere mai. Ana ngā mihi mai oha. Kia koe tuare, kia koe Jacinta. Te punamu o tu kaupeka tā Toitū. You are the jewel of the faculty, and it's so good to be here tonight. On behalf of all my colleagues in the faculty, a big warm welcome to everyone here, particularly Jacinta's family, who it's wonderful to see here tonight, looking fantastic and rightly proud, and her extended whānau, as well as members of her hapu and iwi, Steph and Vanessa, who I met today, and thank you for coming along. It's just made such a difference having both of you here today. Thank you very much for being here. And Edward Ellison, having you here just makes us grounded and everything's just right. And also we have a member here today from the North Island, Ngāti Whātua Tamatirangi, sitting over here, who's been here for a special prize today, so thank you for coming, Tami. I also want to thank all our Te Rūpū Whai Pataki. There are many who've come from all over the country. Te Rūpū Whai Pataki is our Maori Law Students Association, and we've had members coming as far from Northland just to be here today for this lecture. And it's a fantastic tribute to you, Jacinta, the leadership you've done in the faculty. The people have travelled from all over the country. We had the dream team today, and we can take over the world right now. Professor Jacinta Ruru graduated with a BA in politics from Victoria University in Wellington in 1996, and then saw the light and got an LLB from the University of Otago in 1999, and an LLM from the University of Otago in 2002, and a PhD from the University of Victoria, Canada in 2012. Professor Ruru began her professional life as an assistant lecturer in the Faculty of Law at the University of Otago in 1999, and what a vision we had at those days, appointing people as assistant lecturer. You hear that, Vice Chancellor? It's a very important thing to do. She was appointed lecturer in the faculty in 2002. She was promoted to senior lecturer in 2006 and to associate professor in 2012 before her promotion to professor in February this year. Professor Ruru's research work draws on indigenous law, common law, property law, international law, comparative law, critical legal studies and law, and geography theory to consider the rights and responsibilities that indigenous people have to own, govern and manage land and water. Professor Ruru has published 9 sole-authored and co-authored books. Professor Ruru's major international book, Discovering Indigenous Lands, written in collaboration with leading international scholars from Canada, United States, Australia and Scandinavia, was published by Oxford University Press. Professor Ruru's chapters in the book are described by a reviewer as simply brilliant. Professor Ruru has also published 33 book chapters in her field of expertise. The books are published by a wide range of international publishers, ranging from Toronto University Press, Vancouver University Press, British Columbia Press, Oxford Hart Publishing and Ashgate UK, as well as well-known New Zealand publishers such as Bridget Williams Books, Otago University Press and LexisNexis New Zealand. Professor Ruru has also published 42 journal articles in refereed journals ranging from the Lewis and Clark Law Review, the Australian Indigenous Law Review, the Monash University Law Review, West Virginia Law Review, the UBC Law Review and the Indigenous Law Journal published by the University of Toronto. Professor Ruru has presented often as the keynote speaker in many of these, at 55 international conferences around the world, and given this university and this faculty a tremendous international reputation. We thank you very much for that, Jacinta, on her specialist area of Indigenous peoples law. As a result of all this outstanding research, Professor Ruru has won a number of research awards, including the Otago University Early Career Award for Research, the University of Otago Roheath Trust Award and Carl Smith Award for outstanding scholarly achievement in the first 10 years of one's career. Jacinta Ruru has also received a number of grants, over $500,000 worth of grants. And this year, as we just heard, from Tuari, she was awarded the Fulbright Toitū Maramatanga Senior Maori Scholar Award in 2011. Last year, she was appointed the co-director of Ngā Pai o Te Maramatanga, New Zealand's Maori Centre of Research Excellence, which has the responsibility, and you're the right person to be doing this, Jacinta, of distributing $25 million of funding amongst Maori researchers in New Zealand. It's a fantastic honour for you to be given that co-directorship, and we congratulate you on that. Professor Ruru is also an outstanding teacher of distinction. In 2013, she was awarded the OUSA University of Otago Students Association New Supervisor of the Year Award for her postgraduate research. In 2015, she inaugurated and became director of the Te Ihaka Building Maori Leaders in Law program, which has been a great success. Also in 2015, Professor Ruru was awarded the University of Otago Kaupapa Maori Teaching Excellence Award, and as we heard, just last month, she was awarded the Prime Minister's Supreme Award for Tertiary Teaching in New Zealand. It's a fantastic teaching regime you have there, Jacinta. On top of all this, as we've heard from the Vice-Chancellor, Jacinta has worked tirelessly in service. She's served on numerous faculty, divisional university committees, as well as working parties within the university. But also outside the university, you've worked tirelessly with your iwi and many iwi throughout the country, communities, ministries, government departments, and giving your expertise in a very generous and tireless way. And you've brought up 2 children and keep an eye on Andrew through all that. It's unbelievable. So it's my great... Poor Andrew. It's got to be the fall guy, Andrew, that's you. So I now have the greatest honour and the really greatest pleasure to invite New Zealand's, as we heard from the Vice-Chancellor, first Maori law professor, Jacinta Ruru, to give her inaugural professorial lecture, Te Toitū te Whenua, Te Toitū te Manawa.
Ka tangi te titi, ka tangi te kaka, ka tangi hoki a hau. Ko ranganui, kōrua, ko papatūnuku, ki waho nei, tēnā kōrua. Ko te whare e tū nei, tēnā koe. Ko te mana whenua o tēnei rohi, tēnā koutou. Te hunga mati, hunga mati, haere, haere, haere. Nō reira, tēnā koutou, tēnā koutou, tēnā koutou katoa. Ko panihora katoa, te maunga, ko mangawhero te awa, ko tainui te waka, ko raukawa te iwi, ko Ngāti Mōtai Ngāti te apunga te hapu, ko te apunga paparamu te marae, ko karanama te tangata, ko Ngāti Ranganui me Ngāti Maniapoto, ngā iwi hoki, ko John Ruru, rawa ko Katarina Ormsby, ngā tipuna. He mihi nui kia koutou. I thank you for being here this evening with my whānau to mark this occasion and to indulge me in this opportunity to talk about my research journey. In particular, I acknowledge the CEOs of my koro and my nanny's iwi, Vanessa and Stephanie, the rangatira of this university who walked in with me this evening, led by Professor Harleen Hain, and to all those who have travelled to be here this evening, and to all of my colleagues and friends, both present and absent, thank you. So to begin, I was born in 1974, December 1974, on the eve of political and legal change. Those who marched the length of this North Island demanding not one more acre of Māori land, and those who engineered the Labour government to establish the Waitangi Tribunal were landmark events that changed our legal system and laid the platform for all that has been done since. I was, of course, then oblivious to all of this. I was instead encased deep in the South Island at the head of Lake Wakatipu, Glenorchy, at the foot of majestic mountain peaks and forested river valleys. We were far away from Dad's childhood stomping ground of our tribal lands of Raukawa, where he grew up next door to the humble whānau Paparamu marae, bookended by my nanny's tūranga waiwai of Ngāti Ranganui and Ngāti Maniapoto. And we were far away too from my Pākehā mother's upbringing in her loved city, New Plymouth. Growing up in these Te Waipounamu lands around Lake Wakatipu, walking the national park trails with my mum, scrambling along neighbouring mountain tracks with Dad, who mined for sheelite and hunted possums, I knew these places were of significance to Ngāi Tahu, but present instead to the general public was merely the overlaid English names in the Department of Conservation. Something seemed amiss and remiss. This childhood unease with a place that I adored so much led me on my adult journey of inquiry, and eventually dreaming for better, more respectful law to acknowledge Indigenous peoples' rights, responsibilities and interests, to remain governors and stewards of the lands and waters essential to cultural identity and survival. The discipline of law took hold of me in the 1990s. It was a chance encounter. It was not always obvious I'd go to university. Few we knew had. I was really inspired in my Central Otago schooling. This changed in fifth form when I read for the first time a short story by a Maori author about racism in our country. And I knew then I'd go to university because I wanted to know more. I thought then my career would be in documentary making to better understand colonial injustice in our society. But once I began the study of law, I was hooked. I liked how I could build an argument to support a cause to be heard in a forum that had to take seriously at the courts. I loved the university environment for learning, and I particularly loved the puzzle of law encased within the protective mantle of Te Rōpū Whai Pūtaki, the Māori Law Students Association. All the law teachers motivated and encouraged me in my learning, but I struggled with much of the curriculum. It was perplexing to sit in lecture theatres learning about legal positivism, primary rules and secondary rules, clear cases and hard cases, all containing underlying messages that law is objective and just. I could not reconcile the standard of law with the stories of my father's family. These stories are about dispossession from ancestral land from the 1860s onwards through insidious legislation and local government rules. I knew our experiences were not unique. All Māori families tell of similar accounts. These experiences were mostly invisible. Studying law gave me the insight into how the law was used to achieve colonial goals. It did not convince me that law operates in an unbiased, neutral terrain. And so I came to regard the subject of law as both shocking and fascinating. But the discipline of law was changing. Iwi hapu whānau, who have always sought justice since 1840, were making gains. That Māori success in the 1975 that began the catalyst for future change. In my childhood in the 1980s, the Waitangi Tribunal's jurisdiction was extended back to 1840, recognising that the Crown had a long history of seriously breaching the principles of the Treaty of Waitangi. Parliament enacted legislation for the first time in a contemporary sense that made decision makers acting under the State-Owned Enterprises Act 1986 to not be able to act inconsistently with treaty principles. And the court finally overruled the legal precedent that had been on the law books for more than 100 years, positioning the treaty as a simple nullity. So Māori were changing the legal landscape, and our branches of government were listening and responding. And amongst this change, in 1999, I quietly transferred from an LLB student to assistant lecturer because the then Dean, and now late Professor Richard Sutton, took the gamble to awhi and support me into a legal academic career. And he did so by organising with Te Rōpū Whai Pūtaki, the Māori Law Students Association, at the time led by the formidable Paula J. Wilson and the late Jolene Patuawa, and Rachel Mullins and Tradine and James, who are all here with me this evening. A mihi whakatau that brought into the Richardson building Kai Tahu and my family with proceedings led by Edward Allison. And then the Dean sent me off on a leisurely month to introduce myself to the handful of Māori academics at the other law schools, so I would have a network of colleagues. It was an extraordinary gesture and one offered with deep insight, recognising that the influence of Māori in law was still new. It was only a generation earlier that Māori began graduating in law in any numbers, with one of our first Otago Māori graduates being Wilson Isaac, who is now the Chief Judge of the Māori Land Court and Chairperson of the Waitangi Tribunal, and who we have named our Te Ihaka Building Māori Leaders in Law program in honour of. So returning back to campus, this network grew. For most of my employment, Professor Mark Hennigan has steered the law faculty and believed in what I have sought to do. He is the most remarkable leader who always finds ways to say yes. Beyond the Faculty of Law, Te Tumu embraced me with a formal welcome. Staff Women's Caucus opened their arms and brought me into an across-campus network. And in a little side room in Clubs and Socks, I found my comrades, the handful of Māori staff from around the university, where we'd meet to support and inspire one another, initially under the umbrella of the Māori Union, then as Awhi Mai Awhi Atu, and more recently as Te Poutama Māori. Beyond Otago, the Māori legal community, most prominently Ngāi Tahu Māori Law Centre, the Māori Land Court Judges, and Te Hongaroia Māori, the Māori Law Society, were all there with me and, well, got me to work. My academic career was off before I'd even had a chance to figure out the topic of my master's thesis. Reflecting back on my research career, these are the three key catalysts that have shaped my career. So the Ngāi Tahu Claims Settlement Act captured my attention. How could it not? It spoke to Ngāi Tahu relationships with the lands of my childhood. Here was legislative recognition that Mount Hearn's law was Pakadakatahi. I wanted to know more, and I wanted to understand why lands obviously so important to Māori were locked up in national parks, with a legal ethos that is and remains premised entirely on monocultural Pākehā values for protecting land. Most obviously, an inherent cultural divide exists in conservation law that goes to the heart of how Māori and Pākehā differently view the world. Through Pākehā eyes, and thus the lens that has dominated legislation, is the one that embraces tightly preservation for protection of treasured landscapes and native species. Exceptions exist for permitting the New Zealand cultural passion for salmon and trout fishing, even in national parks where introduced species have decimated native species. No or very little exceptions exist in law for permitting the cultural activities of Māori, despite native flora and fauna being integral to cultural identity and survival. The purpose of the National Parks Act in Aotearoa, New Zealand, is to preserve in perpetuity as national parks for their intrinsic worth and for the benefit, use and enjoyment of the public areas of New Zealand that contain scenery of such distinctive quality, ecological systems or natural features so beautiful, unique or scientifically important that their preservation is in the national interest. Completely absent is the Māori relationship with these lands. The Ngāi Tahu Claims Settlement Act was the first statute to punch significant holes into the walled national parks to let breathe again the Ngāi Tahu understandings of the lands, the national parks and their takiwā. The reconciliation mechanisms within this statute recognise that Auraki Mount Cook is an important ancestor of Ngāi Tahu and that the maunga will be returned to Ngāi Tahu for a period of 7 days when they wish to action this. At the expiry of the 7 days, the mountain will be gifted back to the nation. It also provides Ngāi Tahu representation on relevant conservation boards and the New Zealand Conservation Authority, and lays a tōpuni over stretches of national parkland that emphasise the Ngāi Tahu values, their cultural, spiritual, historical and traditional associations with that particular area. Fast forward to this country's most recent treaty settlement concerning a national park, Te Urewera. Te Urewera, named a national park in 1954 and managed as Crown land by the Department of Conservation pursuant to the National Parks Act 1980, became simply Te Urewera on the 27th of July 2014, a legal entity with all the rights, powers, duties and liabilities of a legal person. Te Urewera Act is undoubtedly legally revolutionary here in New Zealand and on a world scale. All treaty settlement statutes, including most certainly this one, show that dreams are possible even in an imperfect legal and political matrix. Te Urewera Act makes it clear that those lands cease to be Crown land and cease to be a national park. Te Urewera is now not managed by the Department of Conservation but by a new Te Urewera board. This board is responsible to act on behalf of and the name of Te Urewera. The board, in contrast to nearly any other statutorily created body, encourages acknowledgement of Māori law. The board can consider and give expression to tūhoitanga and tūhoi concepts of management, such as rāhui, tapu me noa, mana me Maori, and toho. And the board must consider and provide appropriately for the relationship of iwi and hapu and their culture and traditions with te urewera when making decisions, and that the purpose of this is to recognise and reflect tūhoitanga and the Crown's responsibility under the Treaty of Waitangi. This statute uses beautiful language to explain why te urewera is so important. And it makes it a very unique statute for doing so. It describes in the legislation te urewera as an ancient and enduring, a fortress of nature, alive with history. Its scenery is abundant with mystery, adventure and remote beauty. Te urewera is a place of spiritual value with its own mana and mauri. Te urewera has an identity in and of itself, inspiring people to commit to its care. For tūhoi, te urewera is the heart of the great fish of Maui. It is their place of origin and return and their homeland. Te urewera is prized by other iwi and hapu, and te urewera is prized by all New Zealanders as a place of outstanding national value and intrinsic worth. It is treasured by all for the distinctive natural values of its vast and rugged primeval forest, and for the integrity of those values for its indigenous ecological systems and biodiversity, its historical and cultural heritage, its scientific importance, and as a place for outdoor recreation and spiritual reflection. The Honourable Dr. Smith, Minister of Conservation in the 1990s and again in 2014 when te urewera was in its third reading, stated, reading from him, "It is surprising for me as Minister of Conservation in the 1990s, who was involved under the leadership of the Right Honourable Jim Bolger, who was in the House then, and the huge debate that occurred around the provisions of the Ngāi settlement in respect of conservation land, and how far this country and this Parliament have come when we now get to this tūhoi settlement in respect of the treated te urewera National Park. If you had told me 15 years ago that Parliament would almost unanimously be able to agree to this bill, I would have said, "You're dreaming, mate." It's been a real journey, he said, for New Zealand, iwi and Parliament to get used to the idea that Māori are perfectly capable of conserving New Zealand's treasures, at least as well as Pākehā and departments of state. And I agree, this is a profound settlement that was not thought possible 15 years ago. Even on my own writing on a comparative national park study, I concluded that work in 2012 with this statement: national parklands encase the lived homes of Indigenous peoples. Today, the law reflects a new societal goal that seeks to reconcile with Indigenous peoples for the past wrongs of taking their lands and denying them the very means to be true to themselves, their ancestors and their grandchildren. National parks have the potential to play an instrumental role in committing to this reconciliation journey. National parks are symbolic of our national identity and our future, and the parks contain Crown lands that thus enable the Crown to lead in implementing a new way of thinking about owning and managing lands, including national parks. So while I dreamed of and set out options for radical legislative reform when writing that conclusion, I did not know that the horizon for change was so near. The enactment of Te Urewera Act makes me immensely proud to be a New Zealander. It offers hope and inspiration that legislative change is possible, and it gives us heart and courage for us in New Zealand as we consider the future of our relationship as sourced in Te Tiriti o Waitangi. While we have many challenges for relationship building and true restitution, there are some glimmers of hope, and these come from our brave Māori communities and Māori leaders who are and always have pushed the Crown boundaries for justice and what is right. And I hope that the horizon is near for the reform of the National Parks Act 1980. We need a more inclusive Section 4 explanation for the purpose of our national parks, and the Treaty of Waitangi settlement statutes provide the key for how to do this. So while the Ngāi Claims Settlement Act had captured my attention and went on to shape both my theses and lead me on to many wonderful interdisciplinary landscape and geography collaborations, The Court of Appeal decision of Bruce and Edwards stopped me dead. So the unease I had felt in law school as a student came crashing back down on me as a lecturer. The history of converting Māori customary lands into Māori freehold land represents a dark history of New Zealand, where the colonial government and the colonial courts were entirely successful in breaking up the Māori estate. However, that march in 1975 with the catch cry of "not one more acre of Māori land" led to new legislation in 1993, Te Tūri Whenua Māori Act, that supposedly marked a new reformed era with recognition that land is a taonga tuku iho. But this Bruce and Edwards case was the third in a row from the Court of Appeal to permit other legislation and other principles to override this new 1993 Act. Even though the 1993 Act clearly marked a new era for Māori land with the overriding statutory intent to now keep Māori land in Māori hands, no upper appeal court had then found in favour of Māori land retention. So what happened in this case? Essentially, a Māori couple who owned a farming block of Māori freehold land in South Taranaki agreed to sell the land for $2.2 million to a Pākehā farming couple. The agreement was conditional on the vendors first changing the status of the land from Māori land to general land. How to do this? By deception. The vendor's solicitor deliberately misled the Māori Land Court, lying that the general land status would help the vendors to better utilise the land themselves. And the court believed the story, so the land changed to general land. The sale agreement became unconditional, and the Pākehā couple gained an equitable interest in the land. But what about the whanaungatanga, the relatives of this land? The 1993 Act makes it crystal clear that they must be given a right of first refusal before their ancestral land is sold on the open market. The whanaungatanga only became aware of the deception presented in the Māori Land Court through the rumour mill and sought urgent action for the court to rehear the change of status order. At issue in this case was essentially two rights to land. The Pākehā couple, who have an equitable interest in the land following a negligent and deceptive court hearing, and the Māori relatives of the vendors, who have a statutory right of first refusal. The Court of Appeal found in favour of the Pākehā couple, and while the court may have got the law right in deciding this case, there were two deeply concerning things about the case. One, a complete absence in the Court of Appeal judgment that fundamental new drivers of the 1993 Act require the judiciary to appreciate the importance of the retention of Māori land. This driver is captured and repeated in the long title to the Act, the preamble, and sections 2 and 17. The Court of Appeal didn't even mention one of these platforms. Second, the narrative. The judge went on at length that the Pākehā couple would suffer considerable hardship. Why? Because in the court's words, they would have to vacate the farm where they had been living for the past 2 years and would have to relocate their livestock. They are farmers by occupation, but would have no farmland. They would be put in the position of having to try to acquire a comparable farming property at current market values. The value of dairy farms in Taranaki had risen by 1/3 since that contract was made. And it is clear, therefore, that the Bruces would be considerably disadvantaged. In the comparison, and really just a short note, the court acknowledged in brief that the whanaungatanga would be disadvantaged, but not considerably, and in the court's words, we recognise the sorrow the loss of land will cause, as if the whanaungatanga only have a shallow emotional connection to the land. Anyway, I felt it was a travesty of a case. The real travesty, though, is that there were many others just like this that came before it. But this case did mark a turning point, and no subsequent court has failed to mention the pillars of the 1993 Act. The Bruce and Edwards was the first case that I wrote about and marked the beginning of an area of law that has been the mainstay of my research and teaching career ever since. The most remarkable change is that we now have ready access to Māori land court decisions, a given for other areas of law, and consequently a growing deep Māori land jurisprudence. And I mihi here to two here this evening who have contributed enormously to this current work, Craig Lincoln and Dr. Carwyn Jones, co-editors of the Māori Law Review. And I mihi to all others who have helped, especially two Māori academics who did much to support me and who passed away far too young, the mighty Dr. Nin Thomas and the gentle Machu Dixon. He mihi nunui kia kōrua. Māori land is once again in for a statutory shake-up. Significant reform is working its way through Parliament right now. I and many others fear the result will be a return to the pre-1993 days and a return to cases like Bruce and Edwards that just don't get the importance of retention of Māori land for Māori, but also for the nation. So while the Ngaitahu Claims Settlement Act had captured my attention and the Bruce and Edwards case had horrified me, the Ngāti decision brought instant deep relief. This is the famous foreshore and seabed moment, and I read this case with joy. This was it. This was the case that finally overruled conclusively an 1877 judgment that had lived on for more than 120 years in New Zealand case law. In the words of the 1877 colonial judge, Māori are the people composed of numerous dispersed and petty tribes who possess few political relations to each other and are incompetent to act or even deliberate in concert. Māori are barbarians without any form of law or civil government. That 1877 finding enabled a judicial rewrite of history. It overturned earlier case law, declared the Treaty of Waitangi a simple nullity, and introduced a new story of nation building into New Zealand, that the British acquired sovereignty and property of New Zealand, not by cession, but by discovery. In other words, in the eyes of the British, New Zealand was terra nullius, no man's land. And it took a 2003 Court of Appeal judgment to conclusively overrule that 1877 case. And herein lies the issue for Māori in the law. The New Zealand state legal system has, for the most part, been hostile to Māori. This is why the learning of law for Māori students can be hard, and the practice of law for Māori can be tough. The Ngāti case turned this around. It revived an earlier 1847 case and brought New Zealand back in line with early English common law and the contemporary common law developments in Canada and Australia. It held when the common law of England came to New Zealand, its arrival did not extinguish Māori customary title. Title to it must be lawfully extinguished before it can be regarded as ceasing to exist. So the question here was, did Māori title in the foreshore and seabed, land either permanently or temporarily under salt water, still exist? The Court of Appeal held, well, maybe. The place to explore this with evidence would be the Māori Land Court. So the Court of Appeal simply held the Māori Land Court has the jurisdiction to hear evidence and determine if stretches of the foreshore and seabed remain Māori customary land. Of course, within 24 hours, the joy of reading the decision fast turned to bewilderment as the politicians announced imminent statutory reform to ensure iwi hapu whānau would never have the opportunity to bring such a case in the courts. The Ngāti case has defined much of my research. I believe that we do have hope within our common law, inherited from England, to build more respectful law. Ngāti shows us this is possible in theory. While legislation has clearly extinguished any possible Māori common law interest in the foreshore and seabed, there remains uncertainty. For example, with fresh water. I have argued for some time that it ought to be possible. It is wrong for the Prime Minister to espouse simply one component of the common law that says no one owns water. It is wrong because there is another component of the common law, native title, that recognises Māori continuing ownership of property. And so our legal system evolves. Many challenges and opportunities are here right now for New Zealand to embrace a more respectful legal system if we wish. To start, we could reform the National Parks Act, throw out the Te Tūri Whenua Māori Reform Bill and recognise Māori continuing ownership of water. Toitū te whenua, toitū te mana. Or, in the words of the vision for Ngā Pai o te Maramatanga, New Zealand's Māori Centre of Research Excellence, ko te Māori e arataki ana ia Aotearoa ki te ao kei mua. Māori leading New Zealand into the future. So thank you for being here this evening. My many amazing research, teaching and service experiences have only been possible by many of you who are here this evening. Before I close, I must make special mention to my whānau, and especially my parents, my brother and his family, and my sister and her family, for always being there, for always believing that university was a possibility, and for enabling me to do what I've done in my career. To Andrew, my husband, who has been with me every step of the way in this academic career. Here's to workplace romance. You've supported and encouraged all I have done and enabled much. And for bringing your family into my life, especially thank you to my mother-in-law Edith, who together with my parents enriches the lives of us and our children. To all the Māori staff here at the University of Otago, and to all of the Māori law students, past and present, to me you are the heart and soul of this campus, and without you I wouldn't have lasted a year here. Ngā mihi nui kia koutou, tēnā koutou, katoa. Kia ora koutou. Oh, I haven't pushed it.
Tēnā koutou katoa. My name is Tony Ballantyne, and I have the great honour of being the Pro Vice Chancellor of Humanities here at the university. And it is with great pleasure that I'll deliver a vote of thanks to Jacinta. She's delivered a truly excellent lecture, providing rich insights into the development of her research and teaching. And she's taken us on a journey that's taken us from Glenorchy in her early days through the development of her thought and writing to here at the University of Otago and to this simply exceptional year that she's had. In response to the lecture, I would like to underline two key points. First, Jacinta's work, which she's introduced to us tonight, is a vitally important set of interventions into an interconnected set of intellectual, cultural, and legal debates. Those debates are just not about the law itself, but they are also about the legitimacy of different ways of knowing the world and different ways of organising social and economic life. In this regard, I think it is very hard to underestimate the significance of Jacinta's work, as I think it grapples with two sets of issues that stand at the centre of our system of government and our sense of ourselves and our place in these islands. First, the status of Maori and their rights as both tangata whenua and mana whenua. And second, the centrality of nature and natural resources and how we think about these islands, their history, and our cultural identities. In bringing those questions together, Jacinta is making a very substantial contribution, not only to legal thought, but to the intellectual culture of our nation more broadly. And I think we cannot underestimate that contribution. Second, Jacinta's lecture has showcased some of the qualities that led to her receipt of the Prime Minister's Supreme Award for Tertiary Teaching Excellence. I think, as we've seen this evening, Jacinta is a great teacher, but that status is just not about her performance in the lecture theatre or in the seminar room. She is a wonderful mentor, an outstanding role model, an excellent colleague. She is a wonderful figure in the culture of our institution. She's greatly valued by her colleagues in the Faculty of Law. She is an important leader in the Division of the Humanities and in the wider university. She always brings her clarity of thought, her commitment to excellence, and belief in the transformative power of teaching and research to all of her work. I know that everyone gathered here tonight, Jacinta, is simply delighted to be sharing this special occasion with you. So could you all join with me in thanking Jacinta?